General provisions as to inquiries and trials. (337) Tender of pander to accomplice. 1. In the case of any offence triable exclusively by the High Court or Court of Session, or any offence punishable with imprisonment which may extend to 10 years, or any offence punishable under Section 211 of the Pakistan Penal Code with imprisonment which may extend to 7 years, or any offence under any of the following sections of the Pakistan Penal Code, namely, Sections 216A, 369, 401, 435 and 477A, officer in charge of the prosecution in the district, may, at any stage of investigation or inquiry into or the trial of the offence, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to the offence, tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor, in the commission thereof, provided that no person shall be tendered pardon who is involved in an offence relating to hurt or cattle without permission of the victim or as the case may be of the heirs of the victim. Proviso, omitted by federal laws, revision and declaration, Ordinance 27 of 1981. 1a. Every magistrate who tenders a pardon under subsection 1 shall record his reasons for so doing and shall on application made by the accused, furnish him with a copy of such record, provided that the accused all pay for the same unless the magistrate, for some special reason thinks fit to furnish it free of cost. 2. Every person accepting a tender under this section shall be examined as a witness in the subsequent trial, if any. 338. Power to grant tender of pardon. At any time before the judgment is passed, the High Court or the Court of Session trying the case may, with the view of obtaining on the trial the evidence of any person supposed to have been directly or indirectly concerned in, or privy to, any such offence, tender, or order the officer in charge of the prosecution in the district, to tender a pardon on the same condition to such person, provided that no person shall be tendered pardon who is involved in an offence relating to hurt or cattle, without permission of the victim or, as the base may be, of the heirs of the victim. Subs. By Ordinance 37 of 2001. DT the 13th of August 2001. 339. Commitment of person to whom pardon has been tendered. L. Where a pardon has been tendered under Section 337 or Section 388, and the public prosecutor certifies that in his opinion any person who has accepted such tender has, either by willfully concealing anything essential or by giving false evidence, not complied with the condition on which the tender was made, such person may be tried for the offence in respect of which the pardon was so tendered or for any other offence of which he appears to have been guilty in connection with the same matter, provided that such person shall not be tried jointly with any of the other accused, and that he shall be entitled to plead at such trial that he has complied with the conditions upon which such tender was made, in which case it shall be for the prosecution to prove that such conditions have not been complied with. 2. The statement made by a person who has accepted a tender of pardon may be given in evidence against him at such trial. 3. No prosecution for the offence of giving false evidence in respect of such statement shall be entertained without the sanction of the High Court. 339a. Procedure in trial of person under Section 339. The court trying under Section 339 a person who has accepted a tender of pardon shall, before the evidence of the witnesses for the prosecution is taken, ask the accused whether he pleads that he has complied with the conditions on which the tender of the pardon was made. 340. Right of person against whom proceedings are instituted to be defended and his competency to be a witness. 1. Any person accused of an offence before a criminal court, or against whom proceedings are instituted under this code in any such court, may of right be defended by a pleader. 341. Procedure where accused does not understand proceedings. If the accused, though not insane, cannot be made to understand the proceedings, the court may proceed with the trial, and in the case of a court other than a high court, or if such trial results in a conviction, the proceedings shall be forwarded to the High Court with a report of the circumstances of the case, and the High Court shall pass thereon such order as it thinks fit. 342. Power to examine the accused. 1. For the purpose of enabling the accused to explain any circumstances appearing in the evidence against him, the court may, at any stage of any inquiry or trial without previously warning the accused, put such questions to him as the court considers necessary, and shall, for the purpose aforesaid, question him generally on the case after the witnesses for the prosecution have been examined and before he is called on for his defense. 2. The accused shall not render himself liable to punishment by refusing to answer such questions, or by giving false answers to them, but the court may draw such inference from such refusal or answers as it thinks just. 3. The answers given by the accused may be taken into consideration in such inquiry or trial, and put in evidence for or against him in any other inquiry into or trial for any other offense which such answers may tend to show he has committed. 4. Except as provided by subsection 2 of section 340, no oath shall be administered to the accused. 343. No influence to be used to induce disclosures, except as provided in section 3377 and 338. No influence, by means of any promise or threat or otherwise, shall be used to an accused person to induce him to disclose or withhold any matter within his knowledge. (344) Power to postpone or adjourn proceedings, if, from the absence of a witness, or any other reasonable cause, it becomes necessary or advisable to postpone the commencement of, or adjourn any inquiry or trial, the court may, if it thinks fit, by order in writing, stating the reasons therefore, from time to time, postpone or adjourn the same on such terms as it thinks fit, for such time as it considers reasonable, and may by a warrant remand the accused if in custody. Remand, provided no magistrate shall remand an accused person to custody under this section for a term exceeding 15 days at a time. 2. Every order made under this section by a court other than a high court shall be in writing signed by the presiding judge or magistrate. Explanation: reasonable cause for remand, if sufficient evidence has been obtained to raise a suspicion that the accused may have committed an offense, and it appears likely that further evidence may be obtained by a remand, this is a reasonable cause for a remand. 345. Compounding offense. 1. The offense is punishable under the sections of the Pakistan Penal Code specified in the first two columns of the table next following may be compounded by the persons mentioned in the third column of that table. Offense sections of the Pakistan Penal Code: applicable persons by whom offense may be compounded: uttering words, etc., with deliberate intent to wound the religious feelings of any person. 296. The person whose religious feelings are intended to be wounded. Wrongfully restraining or confining any person. 241. 342. The person restrained or confined. Assault or use of criminal force. 352. 355. 358. The person assaulted or to whom criminal force is used. Unlawful compulsory labor. 349. Procedure when magistrate cannot pass sentence sufficiently severe. 1. Whenever a magistrate of the second or third class, having jurisdiction, is of opinion, after hearing the evidence for the prosecution and the accused, that the accused is guilty, and that he ought to receive a punishment different in kind from, or more severe than, that which such magistrate is empowered to inflict, or that he ought to be required to execute a bond under section 106, he may record the opinion and submit his. 350. Conviction or evidence partly recorded by one presiding officer and partly by another. 1. Whenever any sessions judge or magistrate, after having heard and recorded the whole or any part of the evidence in an inquiry or a trial, ceases to exercise jurisdiction therein, and is succeeded by another sessions judge or magistrate who has and who exercises such jurisdiction, the sessions judge or magistrate so succeeding may act on the evidence so recorded by his predecessor, or partly recorded by his predecessor and partly recorded by himself, or he may resummon the witnesses and recommence the inquiry or trial. Conviction was held, if such court is of opinion that the accused has been materially prejudiced thereby, and may order as a new inquiry or trial. 350a. Changes in constitution of benches. No order or judgment of a bench of magistrates shall be invalid by reason only of a change having occurred in the constitution of the bench in any case in which the bench by which such order or judgment is passed